Department 107 of the Los Angeles Superior Court is now in session. The Honorable Michael E. Pastor, Judge presiding. Please be seated.
Let me call the case of People v. Conrad Robert Murray, case number SA-073164. Dr. Murray is present in court with his counsel, Mr. Chernoff and Mr. Flanagan. The people by their counsel, Mr. Walgren and Ms. Brazil. Good morning. Mr. Chernoff, Mr. Gorgian is or is not going to be here?
He is. I don't know where he went, Judge.
Okay. Do you need a moment?
No, I think he'll be in relatively soon. So.
All right. There are various matters we are going to be addressing today. The first of which is the issue of a defense motion not to permit audio and video coverage. I received that submission at the same time I received the other paperwork, and it was a submission authored by Mr. Gorgian, who now is present. May we address that first?
Yes.
Mr. Gorgian, I received your motion to preclude coverage by the live media. I'll be happy to hear your point.
Your Honor, we'll submit it on the papers.
Thank you. Did you serve any media organization?
I did, Your Honor.
Which media organization?
Can I see it? It was the organization that filed the request, Your Honor. It was in session, and the person who served was Carol Gant, G-A-N-T-T.
Is there counsel for any media organization present? I hear no response. Do the people have a position in this issue, Mr. Walgren, Ms. Brazil?
Thank you, Your Honor. The same position we've had throughout, and that is our office policies. We do not object to cameras in the courtroom, Your Honor.
Thank you. Can you amplify, Mr. Gorgian, the basis for your motion? It invites the court to exercise its discretion to decline audio and video coverage on the basis that such coverage would interfere with Dr. Murray's right of privacy. So I was interested in the exact factual basis for that position.
Yes, Your Honor. As the court is aware, the rules of court make this discretionary upon the court whether or not to allow cameras in the courtroom. One of the factors the court considers is the privacy interest of the defendant, and it's our position that the sentencing hearing, Your Honor, is going to get into a lot of personal matters pertaining to Dr. Murray, and his privacy rights are, I believe, something that the court needs to consider, and we would just object to having cameras here based on that.
How does the fact that Dr. Murray may have participated in some television production, whether it's called a documentary, a faux documentary, a reality show, an unreality show, etc., which was shown after the jury verdict in this case and before today's date, which apparently followed around Dr. Murray, and in which Dr. Murray is heard speaking and interacting with his defense team as well as being interviewed. How does that square with your position that having these proceedings televised and recorded today would impact his privacy?
It doesn't, Your Honor. The personal matters that I referenced earlier are related to the character letters that were attached to the sentencing memorandum, certain aspects of Dr. Murray's life that were not presented in the documentary or the interviews that were conducted. You know, there's certain things that go into his, childhood, certain letters pertaining to his mother and other family members that we feel are private and should not be broadcast all over the world.
Okay, they would be a matter of public record, would they not?
They would.
Is it submitted?
It is, Your Honor.
By the people?
Yes, Your Honor.
Thank you. The court has evaluated the various factors contained in the rules of court, balancing and weighing and evaluating all of those factors. I find that these proceedings should and will be televised and audio recorded as well. I feel that there is an overriding public interest in having these proceedings public, and that if there are any privacy interests here, they simply do not in any way, shape, or form outweigh or modify my decision. So the defense motion respectfully is denied. We have the issue involving further proceedings, Mr. Matthew Alford, and I note that defense counsel or defense counsel for Dr. Murray is here, People's counsel are here, and counsel for Mr. Alford is here?
Yes, Your Honor. Yes, Your Honor.
Okay. Mr. Steve Levine, you are here on behalf of Mr. Alford?
Yes.
Okay. I'm going to be addressing... What's that?
Philip Cohen, COH here on behalf of Mr. Alford.
Oh, so both of you?
Yes.
Okay. Well, you're completely different areas of the courtroom. All right. We've got Mr. Levine on one side and we've got Mr. Cohen on the other. I'll be addressing this after these other proceedings, gentlemen, so you're going to have to wait a little bit. At this time, Mr. Chernoff, on behalf of the defense, is there any legal cause why a sentence should not now be pronounced? Mr. Gorgian's conferring with Mr. Chernoff.
We received some information today.
We received some information today from the prosecution for the first time that they some case law regarding legality of imposing a sentence and classifying this as a serious felony. I don't know whether or not that's something that the prosecution is actually going to bring up, but it's a case law that was handed to us today.
What time did you receive it?
Approximately 8:20, 8:15.
Well, I got it at 8:12. Which doesn't please me all that much because I just get a handwritten note from the court staff indicating, oh, by the way, the prosecution is called and they've got 2 cases dealing with the characterization of involuntary manslaughter as a serious felony, and you should look at these 2 cases. So before we go on any further, what's this all about, Mr. Walgren?
Yes, thank you, Your Honor. This is simply the existing statute, 1192.7C8, and in research yesterday, these 2 cases, one dealing with involuntary manslaughter, the other dealing with vehicular manslaughter. It was how they interpreted 1192.7C8 in a gross negligence framework and found it to be applicable, specifically personal infliction of great bodily injury, thus qualifying involuntary manslaughter as a serious felony, which arguably under realignment would make it a custodial case served in state prison. We simply brought it to the court's attention. As it became to our attention, we brought it to the court's attention so the court was aware of it.
Your position is that these decisions of the appellate courts, one from the California Supreme Court, one from the Court of Appeal, which preceded the legislative realignment, somehow change the character of realignment?
No, based on the cases and just a straightforward reading of the cases, in those cases, again, 1192.7C8 was used in sentencing to define those cases, to bring it into a serious felony definition. And I don't think those definitions and that interpretation by those 2 prior court rulings has been altered by realignment. It's simply an interpretation of 1192.7C8. And again, we apologize for the late notice of the court. We just wanted, as we learned of it, we wanted to bring it to the court's attention.
Well, I asked the parties specifically to address the impact of realignment under the state statutory sentencing scheme and Penal Code Section 1170, Subdivision H, which I believe actually lists involuntary manslaughter as an offense which is subject to the realignment provisions. Does it or doesn't it?
I believe that's accurate. And again, we wanted to bring these cases to the court's attention.
Do you feel that these cases in any way, shape, or form alter 1170 Subdivision H of the Penal Code, which imposes a realignment sentencing procedure on the court?
I think that argument can be made. And
Are you going to make it?
We wanted, again, just to make the court aware of it. This is new area of the law, and it's not been subject to much interpretation. And in fairness to everybody, we just wanted to bring these court cases to the court's attention, and we would accept the ruling of the court as to the interpretation. But we thought, in fairness, the cases should be brought to the court's attention.
All right, you brought them to my attention, albeit very, very late. Do the people believe that this offense is an offense which is outside the legislative ambit of 1170H of the Penal Code? Namely, that this offense is an offense which would permit the court to impose a state prison sentence, an actual sentence in state prison for Dr. Murray if the court were so inclined?
Based on the definitions in these cases, I think that's a possibility, yes. But I would understand the argument on the other side as well.
What is the argument on the other side?
The new realignment law, Your Honor.
Well, and presumably the legislature gets the opportunity to define crimes
Yes.
and also define punishment. Fair?
Fair.
And that legislative discretion and power was implemented after the decisions in the cases you cited, correct?
Correct, and we agree with the court.
I don't think these cases have any impact on the realignment statute, for what it's worth, Mr. Chernoff. So that's why I had this little colloquy with Mr. Walgren. I believe the court is bound by 1170H of the Penal Code, whether I happen to agree or disagree with it. So I don't know if that helps you in terms of your presentation, because the question was, is there any legal cause why sentence should not now be pronounced?
There is none.
Do you waive time for sentencing and formal arraignment for judgment?
Yes.
All right, thank you.